Hello, everyone. Welcome back to the YPG conference. We are now going to move right into our next session, that is appointment of arbitrators in multi-party arbitration, to appoint or not to appoint, moderated by Mr. Cameron Sim. Mr. Sim is an international counsel at Debevoise Plimpton, based in Hong Kong. He specializes in international arbitration and complex cross-border disputes with a focus on Asia-related matters. He's admitted in Hong Kong, New York, England and Wales, and Australia. Mr. Sim is recommended for international arbitration by the Legal 500 Asia Pacific 2022, which describes him as excellent and a standout star. He is also ranked by Who's Who Legal 2022 as a national leader for arbitration in mainland China and Hong Kong, and as a global future leader. He draws praise as a superb and unrelenting advocate and a force to be reckoned with. Mr. Sim graduated with first-class degrees in law from the University of Melbourne and the University of Oxford. Subsequently, he clerked for the President of the Supreme Court of the United Kingdom and in the Judicial Committee of the Privy Council. Mr. Sim regularly speaks and writes on arbitration-related topics. The floor is yours, Mr. Sim.
Well, thank you very much indeed for that kind introduction. It's my pleasure to join you at this conference today, particularly on what is such an interesting topic. Multi-party arbitration definitely is a complex area, one which, if it is preempted well in arbitration agreements, can be easier to handle. But in my experience, often it isn't, and it really does throw up a host of interesting and protracted issues, which for arbitration practitioners can be of a special interest, but perhaps for parties embroiled in them, less so. I'm really delighted today to be joined by a very diverse panel from all around the world. I think we now have our full panel as well, so that is excellent timing. I'll just briefly introduce each of our speakers who will be contributing to our wide-ranging discussion today. Joining us from Tehran in Iran, we have Sima Ghaffari. Sima is a member of the Iran Central Bar Association, and currently she's serving as the ICC YAF representative for North Africa, the Middle East and Turkey. She's an associate at Ferdowsi Legal, which is the only active foreign law firm in Iran, as it happens. And Sima represents clients in matters related to international trade and arbitration. Cheryl Teo is joining us from Singapore, slightly closer to home in Kuala Lumpur. Cheryl's a senior associate at Allen & Overy's international arbitration practice in Singapore. And her experience includes advising on a wide range of cross-border disputes all over the Asia Pacific. And she's worked on cases in Singapore, Indonesia, Vietnam, Thailand, China, Japan, India, and Australia, which is practically the whole Asia Pacific. So she has a very busy practice. Cheryl has also worked under all of the leading arbitral rules and also conducts litigation before the courts of Singapore. Joining us from India, we have Ila Kapoor, who's a partner at Shardul Amarchand Mangaldas, and she works within the firm's dispute resolution practice. Ila works on both domestic arbitration season in India and also on international arbitrations, as well as commercial litigation in the Indian courts. And Ila's experience spans across all of the core sectors, with a focus on energy, infrastructure, healthcare, and corporate disputes. And she's worked on arbitrations under a variety of institutional rules, including familiar candidates ICSID, ICC, ICDR, and the SIAC rules. And she regularly appears as advocate before both courts and tribunals. Ila is named in Who's Who Legal as a global future leader. And before her practice in India, which is obviously thriving, she worked for several years at an international law firm in New York, prior to which she graduated from the LSE in London and obtained a master's from Cambridge. And finally, joining us from London, speaking of the UK, we have Ivaylo Dimitrov, who's an associate at OMNIA Strategy. He specializes in international arbitration and public international law disputes as well. And he therefore acts for both private and sovereign clients in multifaceted disputes, including both investor-state and commercial arbitrations. And his practice spans across Europe, Africa, Asia, and the Americas, and he focuses on energy and manufacturing disputes as well. So we have, as I said, a very diverse panel joining us from across the globe, and I'm looking forward to this discussion with them all. To begin, we're just going to start with really what are some opening presentations of sorts, just to give a little bit more context to today's topic and to explore what some of the more complex issues are that we'll come to elaborate on as we move through the webinar. And so a sensible place to begin, therefore, is on an introduction to what do we mean by multi-party, multi-contract arbitration, and what sorts of issues might we expect to arise. So, Ivo, I will hand over to you.
Thank you very much, Cameron. And good afternoon, good evening, good morning, everyone. I know that we have people from all around the globe. I am delighted to be part of this panel. Very esteemed, as Cameron explained, and very diverse panel, and look forward for this interesting discussion. So that from the outset, we will explain what do we mean by multi-party and multi-contract disputes, and I will start from what is multi-contracts and multi-party relationships. So these arise directly from the sophistication of international trade and international business, and come from the fact that nowadays we have complex transactions that involve oftentimes a variety of different entities. Very generally speaking, we can divide them into two sets of relationships. So first we have multiple contracts between the same parties or entities, or secondly, we can have a series of contracts between three or more parties relating to the same transaction or project. Such multi-contract situations can arise, as I said, between two or more parties based on, for example, general agreement, oftentimes called master or head agreement, and then subsequent ancillary agreements, such as financing agreements or service agreements. You can also have long-term framework agreements, which sets out the general terms of the parties' transaction, and then successive application agreements setting out in greater details the terms of the performance of each separate set of transactions as part of this more complex and global relationship. We can also have multiple and separate and distinct agreements relating to the same project or economic operation. So for instance, you can have a company entering into several agreements with banks, contractors, investors, and so on and so forth. Multi-party contractual relationships may also arise and may overlap with multi-contract situations. For example, when you can have two or more parties signing the same agreement as part of joint venture, you can also have one party entering into separate agreements with other parties. So this is, let's say, horizontal contractual relationship. Or you can have a chain of contracts where, for instance, party A contracts with party B, and then party B contracts with party C. So these are situations that can arise in constructions, for instance, or shipping. There's another set of situations, and this is very often a part of my practice in energy disputes. You have large infrastructural projects, let's say in the energy sector, building a power or a renewable plant, which is implemented through a very complex set of transactions. So you can have a power purchase agreement between a state-owned electricity company and independent power producer. You can have an implementation agreement between the investor, the IPP, and the government, which provides for certain safeguards. And you can also have, let's say, financing agreements between the project developer and its lenders and sponsors. Sometimes the government is also party to those agreements. So now that we provided a bit of a background and context, what kind of relationships and what kind of transactions can arise and can give rise to a dispute that involves multiple parties, let's speak about what are the options. And when you have a dispute that arises from such kind of situations, how this dispute can be resolved. So there are two options here. First, it could be resolved in a single set of proceedings by a common tribunal, let's say, or a court or adjudicative body. Because we're speaking about multi-party arbitrations, let's stick to the situation of an arbitral tribunal. When I was preparing for this panel, I've come across several authors and commenters which advocate, so to say, that the best way to handle those kind of multi-party disputes is in a single set of proceedings. I would personally shy away from accepting that this is the default position, because as most of the issues arising in arbitration, the answer will depend on the circumstances and the facts of the dispute. So when we have to decide whether we will go with a single arbitration or a multiple proceedings, we can look at the situation from the perspectives of different actors. So first, the party's perspective. The party's perspective will be driven primarily by strategic and tactical reasons. So for instance, claimants often will want to resolve the dispute quickly, cheaply, and fully. And by fully, I mean to recover as much as possible of what it claims it is owed. Bear in mind, however, that sometimes the claimant will want to have another bite of the cherry and save the option for raising another dispute under another arbitration clause. The respondent. So the respondent may have a variety of interests. So sometimes respondents wish to delay the proceedings. Sometimes they wish to join another party so that they can divide or pass on the risk and the liability. Costs are oftentimes, the driving factor for respondents, especially when you have a state entity on the respondent side, which is cash constrained. Third parties. So the primary interest of the third party when there is a dispute arising out of multi-contracts or multi-party transaction is to protect their interests. So when such a third party will be interested in dispute between other other partners, so to say. So this is when the findings and the determinations of the tribunal in the dispute that has a reason could affect their rights and potentially lead to liability. So in certain circumstances, that third party will want to appear and make submissions. And finally, we have the deciding body. And this could be a court or tribunal or an arbitration institution. So when you have a deciding body which will have to make the decision, the main consideration will be efficiency and fairness of the proceedings, and the factors that the deciding body will have will consider when faced with a dispute, whether there should be a single proceedings or multiple proceedings, are a lot. So I'll just point out to several such factors. First, what do the arbitration agreements say? What is the structure and the interrelation between the separate contracts, the roles and the interests of all parties that are involved? Third, what are the facts? What kind of factual matrix we have before making the decision? Next, who is involved in the dispute and what is the subject matter of the dispute? What the consequences would be for the party that could be left out of the dispute, And finally, but not last, evidence. So how many witnesses each party can bring, how many documents, would those witnesses and documents be very important for the whole dispute or for just part of it? Experts as well. So as you can see, it's kind of a complex situation. So ideally, this should be decided in advance. And because of this complexity, usually practice has evolved so that these issues are all set out in arbitration agreements when the contract between the parties are drafted. So it's not rare that you can find nowadays very complex arbitration clauses that, for instance, define what is a dispute when you have multiple parties under multiple agreements. They even create umbrella terms such as transaction documents or project agreements. Such arbitration clauses set out conditions for joinder and appointment of tribunals by multiple parties and so on and so forth. So these are the preliminary things I had in mind when we're speaking about multiple contracts and multiple disputes. So now I will return the mic to Cameron.
Thank you very much, Ivaylo. That was a very comprehensive overview. And it's interesting, towards the end of your presentation, you used the word complex arbitration. And of course, a lot of the textbooks on multi-party arbitration are actually called complex arbitration. And this is really an area where huge complexity, unsurprisingly, can arise. And I think one of the points you made there, which is how you view this will depend on whether you're claimant or respondent, is a very good one, because often that will dictate the position that is taken in an arbitration on this. There might be an arbitration answer on what would be the most efficient in both terms of time and costs, and most likely to lead to that ideal single set of proceedings. But if these issues haven't been preempted in the arbitration agreement or the underlying arbitration rules, then you do see parties taking often opposing positions, which really just reflect what their specific interests are. So one other point you mentioned was the scope for joinder or intervention of third parties and how that relates to this area. And it's my pleasure now to invite Ila to provide some thoughts on that topic.
Thank you, Cameron, and thank you, Ivo. That was, I thought there were a lot of things you said, which actually, I could have also spoken about in joinder, so I'm going to skip those. Because, of course, when you're talking about a multi-party arbitration, you maybe talk about several parties who had consented to go in for arbitration. But what happens when that consent isn't there at the initial stage and you want to join a party later after the tribunal has been constituted? And that process is called joinder. Now, joinder can happen before the tribunal is constituted, in which case we have less problems to deal with. Once the tribunal is constituted and a party wants to intervene, or either the claimant or the respondent feel like they want to bring in this third party, then that raises some issues which we're going to discuss. Why would they want to do this? Ivo mentioned there could be several factors. The third party may have some very vital evidence to produce in this dispute. He may have a vested interest in the claim and the outcome of the proceedings between claimant and respondent. It could also be to avoid like a multiplicity of proceedings which are not necessary. So a typical example would be, you have an owner who has entered into a contract with a builder. Builder has sort of passed on a large part of that to a subcontractor. There is a dispute with regard to the quality of material or the building. Now, instead of having two proceedings, one between the owner and the contractor, and then the contractor and the subcontractor tries to join the proceedings which are already on. And you can see immediately why this would be beneficial, because you're avoiding, it's such a waste to have two parallel proceedings dealing with the same issue. But what happens, if the subcontractor is trying to be brought into this proceeding and the tribunal has already been created? And that's the issue of consent, which we're going to look at. Another reason why joinder is actually a very useful tool of international arbitration is, you will have an award which will be easier to enforce if it covers all the parties that might be affected by it in the proceeding, rather than trying to enforce it against third parties who weren't party to the actual arbitration at the first stage. Now, as I said, joinder can take place in 2 stages. And when it takes place, the considerations are, of course, different because consent, which is the cornerstone of arbitration, is tougher to imply when it is being done after constitution of the tribunal. So in joinder cases, ordinarily, original parties to the arbitration have to all consent to the joinder. And that consent actually can be even simply by having subscribed to institutional rules which allow for joinder. So if you have included rules of an institution like AIAC, for example, which says that you are allowed joinder, it may be deemed consent that you agreed to join these proceedings if you were related to them. But consent on its own is not sufficient. And that actually brings us to the topic of today's discussion, which is equal participation and equal treatment of parties. Because even if you consent to join a tribunal that has been constituted, you weren't party to making that tribunal, to the appointment of that tribunal, which is considered a right in arbitration. Right? A party has a right to decide who will determine, to nominate their own arbitrator and to decide who will determine the dispute. Sometimes it could be seen as a ground of challenge even after a party has consented. And this obviously raises a lot of issues with joinder and a lot of fear with regard to joinder, because nobody wants to go through an entire arbitration, have the award, only for the award to be later challenged at the end on the ground that I didn't have equal participation in the appointment of the tribunal. Now, this is, in fact, the principle.
Thank you all
which I
very
think,
much for the
Sima is going to
very
talk about the
informative
principle in
session.
Siemens
We'll now
versus
have
Duck
another
She's going to
break, and I will
explain to
meet
us
all of you
what
here
that
again
equal
at 8 p.m.
participation
for our last session of the
constitutes
day,
and what it
which is a
signifies in
hot debate.
international arbitrations. So institutional rules have come up with different ways of dealing with this issue of consent. For example, the SIAC rules, they are on the conservative side, and they would require consent of all the parties. So that's the original party and the intervening party, both for joinder request at the pre and the post-constitution stage. Whereas LCIA rules and ICC rules have been recently amended in 2021. So they require the consent of only 2 parties, the requesting party and the joining party. So presumably if the claimant wants the joinder of a party, but the respondent says, no, I object, the tribunal would still allow the joinder if the intervening party has agreed and consented along with the claimant. Then there are, on the other side of the spectrum, there's the Hong Kong Arbitration Center rules and the AIAC rules, which actually don't require consent at all. They require that the additional party be prima facie bound by the arbitration agreement. And we can see, what constitutes that being prima facie bound. Even in terms of consent, just to be deemed by virtue of incorporating certain institutional rules, that's not always the case. There's a recent Singapore High Court case, and I think it dealt with LCIA rules, which said that just because you agreed this general worded arbitration agreement where you agree to LCIA rules, that doesn't deem consent to joinder. We need something more. We need express writing for joinder to happen. So again, we're in this tricky area where it's not clear, and that's why I think there may be some parties who may think twice before asking for joinder. As I said, like if there is no consent, a tribunal, or if there's no consent, but if there's forced consent, which is when 2 parties have agreed to have the joinder, but not the third, this is called forced consent. What will the tribunal look out for? And they are going to look at a prima facie case to see if they are bound by the agreement. For example, the ICC rules would require a prima facie jurisdiction over the additional party. This is usually a finding of whether the party is covered by the arbitration agreement, whether the party is involved in the dispute. Other factors that a tribunal would consider is what is the timing of this joinder? Has evidence already been led? Would it be completely futile for a third party to now come in because they are not able to present their case? It's too late in the game, as they say, to have this joinder. So I think that would be a very significant factor for consideration with the tribunal. They would consider possible conflicts of interest on the impact of the joinder, both post-constitution, post-award, enforcement, etc. So what do institutions do to reduce the risk of a challenge to the award in cases of joinder? They ask for waivers. So you see there's consent to join the proceeding, and then there is a waiver where you say, I will not challenge the proceeding on the ground that I did not participate in the constitution of the tribunal. So there's an express waiver. So the Hong Kong arbitration rule expressly requires that the party waives all objection to the constitution of the tribunal. The ICC rules, on the other hand, ask for an implicit waiver. So if you have consented to be joined, you are deemed to have consented to the composition of the tribunal as it is and to the existing terms of reference. But both of these make it difficult for a party to then challenge the award on the ground that they do not have equal participation in the appointment of the tribunal. And finally, just to touch on something that is less common, which is making a non-signatory, joining a non-signatory to the proceedings that are going on. And usually we find that this will happen in a court and not before the tribunal. And at least in India, we have Supreme Court judgments where the court will go into the case of a non-consenting, non-signatory party and look at things like piercing the corporate veil, group company doctrines, to see if there is a commonality of subject matter, if there was an intent to be bound by the agreement, most importantly, whether there was a multi-party transaction, related transactions, and then make a finding of whether this non-signatory, non-consenting party can be joined to the proceedings, as it were. So in joinder, it seems like you have to balance the flexibility of allowing a joinder of a party which may be necessary for you to carry on in your proceeding, between the stability of having your proceeding not disturbed and having a final award not challengeable at the end. And basis that balance, you find the institutional rules that work for you and you incorporate those in your agreement. So.
Thank you so much, Ila, for that very helpful introduction of joinder. And I think you mentioned consent really is the cornerstone principle here. And we do see that coming up again and again in joinder applications. But even from your very brief overview, we can see just how complex joining a single additional party to an arbitration can become. I think that's a useful segue now into really the crux of what we're here to talk about today, which is tribunal formation in multi-party arbitration. And so I'll turn now to Sima, who will give an introduction of other cornerstone principles in this context, such as equal treatment between the parties and party autonomy by reference to the infamous Siemens-Dupco decision. So Sima, over to you.
Can you hear me?
Yes, loud and clear.
Okay. Good morning, good afternoon, and good evening. I'm so delighted to be here today among such wonderful speakers, and many thanks to AIAC for organizing today's event and also choosing the topic of this panel. So far, Eva and Ila discussed what multi-party arbitration is. Now, I'm going to briefly discuss the leading .co versus Siemens 1992 case, which has attracted the attention of major players and stakeholders in international arbitration when it comes to the practical challenges of multi-party arbitration in terms of the tribunal formation. So we will better understand the effects of multi-party arbitration on tribunal formation and proper composition of the tribunal. With this, I will start with some facts of the case. There was a consortium concluded between three parties, .co as the claimant of the present case, and Siemens and BKMI as respondents of the present case. And also there was an arbitration agreement, standard ICC clause, inserted to the main contract providing for 3 arbitrators. How? Claimant would nominate 1 arbitrator, and the 2 respondents jointly would nominate 1 arbitrator, and the 2 arbitrators would nominate the president of the tribunal. Then a dispute later arose between the parties, and claimant.co nominated its own arbitrator, and the ICC court, under its rule 1975, requested the 2 respondents to jointly nominate 1 arbitrator. Of course, the respondents did so, but under the protest. And in 1988, the Arbitral Tribunal rendered an interim award on its own jurisdiction and stated that the arbitral proceedings could be pursued in the form of multi-party arbitration. So it left the claimant's right to appoint its own arbitrator untouched, even if the other respondents could not agree on a joint arbitrator. So the respondents initiated an action before the Court of Appeal to challenge the ICC interim award. So a question arises here. What was the decision of the Court of Appeal? The Court of Appeal stated that, first, the multi-party arbitration was generally admissible in this case because the wording of the arbitration agreement between the parties, which shows the true intention of the parties, clearly provided for multi-party arbitration. So the multilateral nature of the arbitration agreement shows that the parties foresaw the possibility of requesting one tribunal consisting of 3 arbitrators to decide a dispute opposing between 3 parties. And second, the Court of Appeal held that the appointment procedure did not violate the public policy and specifically the rights of the respondents to equal treatment. But what happened after? What was the challenging decision of the French Supreme Court? The French Supreme Court annulled the ICC award, and the annulment was based on the lack of balance between party autonomy principles and the rights of the parties to appoint their own arbitrators. And the French Supreme Court stated that the appointment procedure did violated the public policy of France, and it was unfair because it afforded claimants, means .co, a better position to appoint its own arbitrator and to influence the final outcome of arbitration. Also, the Supreme Court of France held that, I quote, equality of the parties in the appointment of arbitrators is a matter of public policy when which can be waived only after a dispute has arisen, end of the quotation. So we see that the challenging decision of French Supreme Court changed the whole scenario because a major player system started to do something to update the rules in order to minimize the risks of the multi-party arbitration when it comes to appointment of the tribunal, and to some extent they deviated from the .co approach. Now I want to echo what Iwa already said. Today, not every contract has 2 parties, specifically in complex construction projects, and also .co case also involved some construction projects. And in maritime sector, in financial sector, where we have borrowers, lenders, and guarantors, and of course, in a myriad of other sectors, we see multi-party arbitration scenarios. So we see the potential conflicts between the party autonomy principle and the right of the parties to appoint their own arbitrators, and also the right of the parties to equal treatment. So I refer to the title and topic of today's panel, to appoint or not to appoint. You know, in Siemens versus .co case, which I already mentioned at least, we see that the parties provide a mechanism for the appointment of arbitrators in their own arbitration agreement. So it appears doubtful that parties negotiating at arm's length require protection with public policy when they have already decided to waive their rights to strict equality in the appointment process before the dispute has arisen. So it seems questionable that in these scenarios, whether really parties require protection by a public policy or not. And after the setting aside of the interim award of ICC in a .co case, many arbitral institutions started to update their rules, and that many rules came under scrutiny. And for example, ICC recently in 2021 has updated its rules and added some provisions in terms of joinder intervention, multi-party arbitration, specifically when it comes to the challenges of the tribunal formation. And many institutions have already introduced a default procedure for appointment of the arbitrators. For example, ICC in its article 12A provides that if the claimants jointly cannot nominate one arbitrator and respondents collectively cannot appoint one arbitrator, then the court shall be at liberty to choose any person it regards as suitable to act as arbitrator. Of course, in next part of the webinar, we're going to address some institutional rules and different approaches in different jurisdictions. And in next part, Cheryl also will cover the issues related to Singapore. And also, last but not least, tribunals with more than 3 members are rare. Of course, I know it exists, but it is considered a bit impractical because it makes the decision-making process and the word writing process at the end of the day even harder. So with this, I'll stop here. Thank you.
Thank you very much, Sima. And just taking up that final point, I have actually myself been involved in an arbitration with a 5-member tribunal, and I think I share your sentiments regarding the issues that throws up. And that's been a very helpful overview of Siemens-Duck-Co, and it certainly is an interesting proposition that in upholding party autonomy and consent in arbitration, the French courts essentially reversed the decision that the parties had initially made. So it is an interesting proposition, and I'm sure we'll have a bit of discussion on that as we continue on. So having heard about all of this, obviously legislatures and arbitral institutes have been very alive to all of these issues, and we've heard a lot already about several institutes that have amended their rules, some of which now include very detailed multi-party provisions. Turning then to Cheryl to finish off our introductory comments. Cheryl is going to give an overview of some of those recent statutory or institutional developments.
Thanks, Cameron. I'm just going to share my screen. Just because I'm going to show a couple of slides. Is that showing on the screen?
Yes, it is.
Okay, so I'll start off here. As Sima mentioned earlier, I think the Siemens and Duck-Co case really prompted some changes to arbitral rules, and it prompted several institutions to change their arbitral rules. And we can see this by comparing sort of the ICC rules that applied to the Siemens and Duck-Co case and the current ICC rules. And you can see that in the ICC rules that apply in the Siemens and Duck-Co case, and that would be the 1988 version of the rules, there was no specific provision in there or no provision in there dealing specifically with the appointment of arbitrators in the multi-party arbitration. The current ICC rules, as Sima mentioned, has very specific provisions dealing with how when you have multiple claimants or multiple respondents, how these multi-parties are to appoint their tribunal. And it also provides that if the parties are unable to agree on an arbitrator, the court may appoint each member of the arbitral tribunal and shall also designate one of them to act as president. In Article 12.9 of the ICC rules, we also see in there a principle in the Siemens and Duck-Co case that's reflected in there. So it says that notwithstanding any agreement by the parties on the method of constitution of the arbitral tribunal, in exceptional circumstances, the court may appoint each member of the arbitral tribunal to avoid a significant risk of unequal treatment and unfairness. So you see that the principle of fairness also being incorporated into the ICC rules in the provisions dealing with the appointment of arbitrators in multi-party arbitrations. So similar concepts appear in the other major arbitral rules. I won't go through them in detail because I think the broad concept is generally similar. So you have these major arbitral rules have incorporated provisions in their rules that deal specifically where you've got more than 2 parties to an arbitration and sets out specific mechanisms for how the appointment process should work. And you see that also in the AIAC rules. So I think all of these provisions pretty much generally they help to address the issue that arose in the Siemens and Duck-Co case. And they make the appointment of arbitrators in multi-party arbitrations a lot more efficient and clear in that the default mechanism is clearly set out. So the specific steps that you need to take, that's all clear to the parties when they agree to a specific set of arbitral rules. So So now that we've seen sort of how arbitral rules have responded to the Siemens and Dutco case, we then look at how national arbitration legislation have developed. And on this topic, the statute that I'd like to highlight here is the Singapore International Arbitration Act, because it stands out from some of the other arbitration legislation from other major arbitral seats, in that I think it's one of the only arbitral legislation that has a specific provision in there that deals with multi-party, the appointment of arbitrators in multi-party arbitrations. So you see here, they've introduced, I think this provision came into effect in 2020, and they've introduced a new Section 9B into the International Arbitration Act. Again, the mechanism here is similar to the mechanism that we see in the arbitral rules. And so there are specific mechanisms in here about how claimants are to appoint an arbitrator, or the respondents are to appoint an arbitrator, and what happens if they fail to agree on an arbitration, on an arbitrator. And it empowers the appointing authority, which in this case, I believe is currently, the appointing authority that's been designated under the International Arbitration Act is the president of the SIAC court. And this, we can compare it with some of the other arbitration legislation. And so, for example, we have here the Malaysian Arbitration Act, as well as the UNCITRAL model law. These statutes have not yet incorporated specific provisions dealing with the appointment of arbitrators in multi-party arbitrations. But I should also say that ultimately, the parties have agreed on a specific arbitral rules to apply, and those rules contain a default mechanism for the appointment of arbitrators in a multi-party arbitration, then those provisions would apply. And it shouldn't really make much of a difference whether or not the statute itself has a default mechanism. I think the statutes will only make a significant difference in the case where the parties have not agreed to a specific mechanism for the appointment of arbitrators. So these were just some examples that I wanted to share in terms of the arbitral rules and the arbitration legislation of the major arbitral seats and jurisdictions, just to give you a flavor of how these rules and legislation have developed since Siemens and Dutco, and how the issue of the appointment of arbitrators in multi-party arbitrations are being addressed right now. And to just be aware in drafting arbitration agreements of the slightly different approaches that each of these rules take. In these slides, I have not covered, there are a variety of issues that some of the other speakers have covered, like joinder consolidation. And all of these rules have specific provisions dealing with all of these issues. So it's always important, I think, to be aware of what the rules, what the default mechanism in these rules say, whether it comes to how you join additional parties to your arbitration, or what it says about appointment of arbitrators. So just to keep in mind what the different approaches there when choosing what your rules should be. And I'll hand it back to you, Cameron.
Excellent. Thank you. Thank you very much indeed, Cheryl. And I certainly, I echo what you've just said, that in these sorts of scenarios, it is vital to check what the underlying rules say. Because in many respects, arbitration rules have become, in relation to core issues, quite similar. But multi-party arbitration is still an area where we do see quite significant differences, as I think we've just seen illustrated by Cheryl. Right, we're now back on screen as well. So look, that was a lot of information that we've got through, but we hope that has provided a useful overview of the key issues that might come up. We're now going to turn to focus more really on broader tribunal formation issues that might be encountered. And sometimes it's useful in this context to consider also standard tribunal formation issues. So in a classic one claimant versus one respondent arbitration. Because sometimes what happens in those scenarios can inform the approach that the Lex Arbitri takes, or that specific jurisdictions take to these issues. So we're now going to canter through our 4 panelists who hopefully all come from jurisdictions which do take quite different approaches, and have them give some anecdotes on what's been going on in their own jurisdiction when it comes to tribunal formation issues, including in relation to multi-party arbitrations. And so we'll head furthest away to begin with over to Ivaylo in London, who will set out the English position.
Thank you very much, Cameron. This is really a very, very interesting discussion, and a lot of thoughts have risen in my mind after hearing the excellent presentations by Sima, Ila, and Cheryl. One thing that stands out in particular is the exchange between Cameron and Sima when they were talking about the challenges after Sima's case. And I know that Cameron mentioned that sometimes it's very tricky to find the balance between fairness and giving the party the right to appoint an arbitrator, efficiency, and public policy. And these are one of the paramount objectives in arbitration in particular. And in my modest experience, it's never the case that you can achieve all of them. There will always be something that is affected. It's just a matter of balance. Anyhow, so this part of my presentation is divided into 2 parts. And the first one will be, I'll just very cursory go through the developments in England in relation to the appointment of tribunals in multi-party arbitrations following Siemens. And there was a very eloquent summary by Sima, and also Cheryl provided a very comprehensive overview, so I'll be very, very brief on that. And the second part is really freestyle, and I'll just share some thoughts I have, some tips. I note that this presentation is part of the broader Vis-Moot and Pre-Moot context, so I think that just giving some practical tips will be useful for the audience. Starting with the multi-party appointment issues in England. So after Siemens, there has been development in this field. First, let me mention that in England, Wales, and Northern Ireland, the default position is that the parties are free to agree on the appointment of an arbitrator or tribunal, which means that the parties' agreement is paramount. And this is reflected in the Arbitration Act of 1996. So when you have multiple parties, usually the way that the tribunal will be formed is governed by the parties' agreement. And this agreement might be an arbitration clause in a contract, might be an agreement reached after a dispute has arisen. Where there is no agreement between the parties involved, then each party may apply to the court under Section 18 of the Arbitration Act, which deals with the failure of appointment procedure. So you will instantly notice that every time you have an issue in multi-party disputes, the solution under English law is that this means there is a failure to appoint. So under Section 18 of the Arbitration Act, the court has very broad powers and discretion. So the court can give directions as to the making of any necessary appointments. The court can also direct that the tribunal shall be constituted by such appointments as have been made already. The court can revoke appointments, and the court may make necessary appointments itself. So let me mention also that Article 18 applies in the case when you have two parties or more which have to appoint a common arbitrator. After the English Arbitration Act, I will go to the LCA rules, the rules of the International Court of International Arbitration in London. I think it was already mentioned that the LCA has adopted new rules in 2020, and there is a specific provision that deals with appointment of tribunal in multi-party disputes. So that's Article 8. Under Article 8, if the arbitration agreement in writing provides for each party to nominate an arbitrator, then what should be considered is whether the parties in dispute have been defined as sides, and that's quite important for the purposes of formation of the tribunal. So, and by sides, LCA rules mean really claimant and respondent. So if they are defined as sides, and each side may nominate a single arbitrator, and the presiding arbitrator will be appointed by the two co-arbitrators or the LCA. That depends on the provision. Well, if there is no agreement as to whether a party is a side, then the LCA court will step in and will appoint the tribunal without regard to any party's entitlement of nomination. So what that means that the tribunal will be fully formed by LCIA. So in my personal view, these solutions under English law are not necessarily straightforward and might be controversial. And this goes precisely to the point of the right of each party to appoint an arbitrator. So in my experience dealing with parties and clients, it's not rare that clients will not like the option of losing their right to appoint an arbitrator and losing the control over the appointment process. I mean, I don't mean to say that we should not trust arbitral institutions, and I know that arbitral institutions have done a terrific job in trying to achieve the balance when they appoint tribunals. And by achieving the balance, I mean promoting diversity, promoting gender equality, and generally trying to find the best way to form a tribunal. However, the reality is that one of the key benefits of arbitration is the right to choose who will decide your disputes, and most of the parties involved in disputes will want to exercise that right. So that's the first part of my presentation here. And then the second part, as I mentioned, is very freestyle. So I'll just share several tips I have in mind. So first, when you have two or more parties and they have to select a common arbitrator, one thing you have to consider first is whether these parties are controlled by the same person or entity, and whether they really represent a one side of the dispute. So, for instance, in investor-state disputes, you will have a situation where a request, a case is initiated by both a foreign investor and its local vehicle, and the reasons are jurisdictional. The reason might be also for recovery purposes. So, when you initiate an arbitration through multiple vehicles, you, so to say, can maximize the chances of finishing the arbitration in case one of the parties is struck out for jurisdictional reasons, or recover as much as possible. So when that's the case, and when you have the same counsel as several different claimants, then I would say it's easier, because I don't think there will be issues in appointing a common arbitrator. The difficulty arises when you have two separate parties which have to appoint a single arbitrator, and these two separate parties might have different interests, might have different considerations in mind and objectives in the arbitration. So the way that they can reach an agreement as to who their arbitrator will be is, discussions, negotiations, generally compromise. One creative solution I have in mind, or if you can't reach an agreement, is for the parties to adopt one of the, let's say, ranking procedures, which are usually used for chair selection purposes. So that means, for instance, they can draw up a list of arbitrators, and they can exchange the list with striking some people, and then they can rank the others. So when you rank the arbitrators, the person who achieves highest score will be selected. That way, the party can still be in control and avoid going to the court or the institution to appoint the arbitrator. And let me again say that I don't mean to say that courts or arbitral institutions are not trustworthy. Exactly the opposite. It's just, as I said, sometimes the reality is parties want to be in control. Another consideration, that's something that Cameron and Sima discussed, is the difficulty when you don't have a three-member panel or a sole arbitrator. So when you have, and I can imagine the issues that Cameron had to deal with in his 5-member panel, but apart from the complexity in reaching an agreement, then you can also have issues with costs, because that really increases the cost of the arbitration. Another point here is you really need an even number of tribunals. I have never come across, and I'll be interested in hearing from the other panelists whether they've come across a tribunal that consists of even number of arbitrators. So that's, I think it's quite rare, or almost impossible to have. So imagine you have 3 parties with each one wishing to appoint an arbitrator. You have 3-party appointed arbitrators. The logical next step is to appoint a chair. Well, if you appoint a chair, then you will have 4 arbitrators, and this might create challenges in forming majority. Another broader issue when you select arbitrators is due diligence. So especially when we speak about party-appointed arbitrators. And as I said, here I concentrate mainly on practical considerations. So apart from conducting, let's say, a desktop due diligence, going through what the arbitrator has written, has shared in terms of personal view, has adjudicated in other disputes, it's also important to conduct an interview. And that's a matter that should be treated with care, because you can create issues and conflicts. So arbitrator interviews are a very delicate topic. A particular advice I have in mind is, when you interview an arbitrator, is to gently inquire about the fees, because there could be unpleasant surprises, especially for clients, when you don't know, the range in advance. Also, when you form a tribunal, I think it's one of the most important things is think how the tribunal will work together as a whole. So you don't take into account only the credentials, the expertise, and the views, but also cultural background, character traits, past relationships with other possible members of the tribunal. And here, I'm sure that our panel consists of experienced counsel, and they know what kind of due diligence is here involved. Oftentimes, it depends on on personal experience, on experience of other members of the team, and also reputation. And since I was supposed to speak about England in particular, one thing I always noticed here is that if one of the parties has appointed a Queen's Counsel QC and the dispute is governed primarily by common English law, then oftentimes you will end up with a tribunal consisting of QCs. So that's a cultural and traditional issue that can often be faced in England. When we were speaking about character traits, another point is, which is very trendy at the moment, is psychological profiling. So you have outfits that offer psychological profiling of arbitrators based on, their decisions, based on any sorts of intel. And so especially if you have high-profile disputes, sometimes parties will procure such profiling and will consider it when they decide how to conduct the arbitration. When we speak about selection of chair, then one of the important points here is to think when to confirm availability and lack of conflict, because that might create an issue. So in my practice, I had instances where we've been through a very complex chair selection process with rankings, but we haven't cleared conflicts and availability. So once we had the ranking, we went to the arbitrators, to the first arbitrator. He was not available, the second was not available, and you can imagine we have to go back to square one and repeat the process. So, it might be sensible to clear conflicts in advance with the list of chair options you have in mind.
Thank you very much, Ivaylo. I think in the interest of time,
I'm running out of time, right?
Yes, we might need to move on.
Sorry about that.
That's been a very, very useful overview of England. And I think we might move now very quickly just through our remaining jurisdictions. And actually, Ila, I guess the Indian law position can differ slightly to that under the UK Arbitration Act, but I will hand it over to you for some.
Thanks. And Cameron, I sense you're getting nervous about the time, so I'm going to be really quick. A lot of what Ivo said, it resonates in India. We follow a very similar system. To answer your question about the even number of arbitrators, the Indian Arbitration Act actually doesn't allow you to have an even number of arbitrators. I imagine that would be the case in most jurisdictions, but I'm not sure. Interestingly, you mentioned that if a QC is appointed, then it's likely that the entire panel will be constituted by QCs. And it's a very similar position in India. We have a situation where very often a retired judge will get appointed. And then you have a position where if you appoint a retired judge of a high court, you're stressed that the other side is going to appoint somebody who's a retired judge of the Supreme Court. Your panel is already becoming really expensive, not to mention top heavy and busy. So this is a situation that we face in India a lot. Something that is peculiar to India, I think, and that I want to talk about is unilateral appointments. I don't know how common it is in other jurisdictions. But in India, especially, it used to be an issue because one of the biggest litigants is the government of India and its entities, right? Its public sector undertakings. And very often they would have a arbitration clause which provided for unilateral appointment. And it would say that either my managing director or the chief engineer will be the arbitrator. It's not easy for a commercial party which really wants to have a contract with the government of India or a public sector undertaking. They don't have much bargaining power, and they would obviously at the time of getting the contract sign this agreement. Once disputes broke out, challenges would of course happen that, though I agreed to this, it's clearly a biased and prejudiced arbitrator or award, etc. So there was an amendment to our Arbitration Act which said very clearly that any employee consultant to one of the parties is ineligible to be an arbitrator. So you would think that would be the end of this issue, but not quite, because then they started appointing, the managing director said, well, I'm ineligible to be an arbitrator, but I'm going to appoint the arbitrator. There's nothing in the act that says that I can't appoint. And then we had case law which says, well, if you're ineligible to be an arbitrator, you're ineligible to appoint one. So that was clear. Then we started getting these clauses which said, well, we'll have a panel. You can choose from a panel. You can choose either the sole arbitrator or your nominee from a panel. And then there's a lot of jurisprudence on this. What is a panel legal? And then where the law comes down is if it's diverse enough, it gives enough choice, then it's allowed. So a 5-member panel is considered too small. But even a 37-member panel in a case recently, they said most of these people are your employees and ex-employees. Only 8 of these people are actually people who have no connection to the dispute. So this is not diverse enough. And then finally, we have a question of, okay, employee, current employee, not allowed. Ex-employee, is that allowed to be an arbitrator? And the answer seems to be from the courts to say yes. I mean, unless there's an apprehension of bias, you can have someone be an arbitrator who used to be employed with you 10 years ago, etc. So this is an area of law in India which is constantly evolving, and we're curious to see where it goes next.
Thanks very much, Ila. And that's really interesting to hear the way those developments have unfolded, and a discussion that I think I'll take the panel to an end. But just to whet your appetite now is whether actually the easiest way out of this all is just to take party appointments out of the party's hand in multi-party arbitrations and into the institute's hands. But we will come to that. Sima, what about Iran? What has been going on in your jurisdiction?
Yes, thank you, Cameron. Of course, in the interest of time, I will keep my time and try to summarize what I'm going to address. I'll focus on the Iranian arbitration legislation where I'm based in and where I am a qualified lawyer in. First, in order to enhance the familiarity with the Iranian arbitration landscape, it is important to note that Iran has adopted dualist arbitration regime, one for domestic arbitration and one for international arbitration. Domestic arbitration is where both parties are Iranian and the seat is in arbitration. International arbitration is where at least one party is non-Iranian and the seat is in arbitration. So the nationality here distincts the domestic and international. And domestic arbitration is governed by the Civil Procedure Code, and international arbitration is governed by LISA, Law on International Commercial Arbitration. LISA was adopted in 1988, but still it contains some provisions regarding multi-party arbitration. It is like the approach of some other legislations where claimants cannot claimant's side cannot collectively nominate one arbitrator, or respondents collectively cannot appoint one arbitrator, then the public court of Tehran will be competent to appoint arbitrators. So it's clear that it involves the ad hoc arbitration cases. And in terms of institutional arbitration, we have 2 leading arbitral institutions, ACIC, which stands for Arbitration Center of Iran Chamber, and TRAC, which stands for Tehran Regional Arbitration Centers. Both these arbitral institutions contain some provisions regarding multi-party arbitration, and they are like the same as other leading institutional arbitrations where claimant side or respondent side cannot appoint one arbitrator, for example, jointly in multi-party arbitration, then the center or the tribunal will appoint the arbitrators. And the other issues related to, for example, replacement of arbitrators or challenging arbitrators will be governed by the laws applicable to the 2-party arbitration. As I told you, there exists some legislation, some articles regarding multi-party arbitration, but it mostly involves the situations where parties have a bipolar interest. I mean, we can categorize the parties as claimant and respondents. It is not clear exactly what would happen if the parties have multilateral interests. And the laws are silent in this regard. And as to the joinder intervention, in terms of institutional arbitration, we have some mechanisms, but it's not enough. I mean, it is not exactly clear, for example, if the joinder or intervention comes after confirmation of the arbitrators, what would happen? The law is silent. And in terms of, for example, ACIC arbitration rules, we have some provisions that if a party wants to join arbitral proceedings, the third party, I quote, shall accept the arbitration agreement, the appointed arbitrator, and the arbitration arbitration rules, and the intervention should not be objected by neither party. If a party objects to the intervention of the third party, the arbitrator shall first decide on the matter, and his decision is final. So, the rules, the institutional rules need to be updated, and Iran is on its way to be a friendly, arbitration-friendly jurisdiction, but yet I cannot claim that it is arbitration friendly. But I know that soon the rules will be updated. For example, I know that ACIC is working on a project to update its rules, and I'm sure that they will contain some provisions regarding the topical issues and trends in arbitration, and for sure the tribunal formation related issues and multi-party arbitration related issues. And to my personal experience, I have not been involved in a situation of multi-party arbitration. I was sole arbitrator and co-arbitrator. It wasn't related to joint intervention. And also yesterday, I asked some of my colleagues to see whether they have such experience, which they didn't. So in practice, I don't know whether we encounter with some challenges or not, but at least I can claim that the rules really need to be updated. And also, yesterday I was thinking what to add when I want to broadly talk about tribunal formation in Iran. And I was thinking it's very good if briefly I mention the nationality requirements. According to LISA, which I already mentioned, that it governs the international arbitration in Iran, it provides that before a dispute arises, the Iranian party may not submit the disputes to one or more arbitrators which have the same nationality of the other party. So the arbitrators here must not be of the same nationality as one of the parties, I mean the other party, before a dispute arises. So it's a very important element to be taken into consideration when drafting arbitration clauses in Iran. And another factor which needs to be taken into consideration when forming a tribunal is related to diversity, which it really needs to be ensured in Iran. And we don't see diverse panels, both in ad hoc arbitration and institutional arbitration, and even the number of females being listed in the list of the arbitration institutions is not, I think, enough. So, but I'm sure we will have some updates in future soon. And yes, with that, I'll stop here.
Thank you very much, Sima, for that very helpful overview. I mean, it really actually has got me thinking about the differences here that you can encounter between how these issues are approached in arbitration rules, whether statute in the law of the seat is up to date or requires updating. And often you can see really different understandings and conceptualizations of consent, equal treatment between the parties, party autonomy, what that means. And it may well be that the arbitral institute whose rules apply to the dispute have a very different perception of those matters than, say, the law of the seat of arbitration or even the law of the place of enforcement. And it seems to me it's really in that latter context that these issues really can come to the fore in multi-party disputes. And the unwelcome news for international arbitration users is that often it's too late, because it's not only at that enforcement stage that you want to find out a lot of these issues have rendered your award unenforceable under the public policy of the law of the place of enforcement. And so, as you say, Sima, I think the need for legislatures and institutes to update their rules, reflect party expectations, and really all of these developments that have taken place in the 30 years since Siemens.co, I think it's really important, because otherwise it really does a disservice to international arbitration, where we are seeing awards, defenses to recognition and enforcement succeed on the basis of these wide public policy arguments that might not necessarily reflect what the parties actually intended and agreed to. But just sorry for that interjection, Cheryl, we do need to finish up our tour of jurisdictions, so we'll head back to you in Singapore for any anecdotes that you have at your end.
Yeah, thanks, Cameron. And that was actually a really nice segue to what I was about to cover, which, I mean, I think Singapore is generally known to be an arbitration-friendly jurisdiction. So it's generally really difficult to challenge an award in Singapore. So being arbitration friendly and being pro-arbitration, I think that's generally seen as a good thing, but it's probably not such a good thing when you're on the receiving end of an unfavorable award and you're trying to challenge it. So I think the thing to keep in mind about Singapore, and I think this is common as with many other established arbitral seats, is that it's really hard to challenge an award or an unfavorable award that you're not happy with. So it's really careful, and I think that brings us to the point that it's really important that you're careful about who you appoint on the arbitral tribunal, to give yourself the best shot at getting the best outcome that you could possibly achieve in a case, because challenging an award is just so difficult. And I just wanted to pick up on the point that Ivo mentioned on doing due diligence on arbitrators and how you pick an arbitrator, because that's a question that we get asked a lot by clients, is how do you, who should we pick to be on our arbitral tribunal? And I think that's obviously a really complex and complicated question, and there's no right answer to it. But for me, I think one of the really important factors that determines who you should pick on your arbitrators is what your case strategy is and what the strengths and weaknesses of your case is. So it's really important to think about those issues and to map out where the strengths in your arguments lie, where the weaknesses lies right from the very start when you're choosing who your arbitrator is. And another thing to note is that the arbitrator you choose does not necessarily have to be an expert in or even qualified in the law that governs your contract. And so I've been involved in cases where, for example, in one of the cases that we did, the contract was actually governed by Japanese law, and it involved a claim for wrongful termination. So our client was the respondent in that case, and the claimant was asserting that our client had wrongfully terminated the contract. So we felt that we had a really good case on the interpretation, on the strict interpretation of the contract itself. And the other side's case was based on sort of broad principles of good faith and the concepts of like these long-term ongoing contracts under Japanese law, and an assertion that our clients had not acted in good faith in terminating contracts. But putting aside the issues of good faith that the other side tried to introduce into the mix, our clients actually had a really strong case on the contract itself. So in that case, it actually really helped to appoint someone that we felt would sort of see the contract or sort of interpret the contract in the way that we were arguing it for, and sort of give a strict interpretation and a black letter interpretation to the contract. So we ended up appointing someone who was not qualified in Japanese law at all. And we got a pretty good outcome in that case. And I think you could see from the award that the tribunal agreed with our interpretation in that case. So I think all of that is to say that when you're choosing who your arbitrator is, you should always look at, how do you think that arbitrator will rule on some of the issues, and how they see some of these issues. And it's important, I think, to pick someone who you think will be persuaded by your case. And that's not necessarily someone who's an expert in the law that governs the contract.
Thank you very much, Cheryl. Well, that has been as well a very wide-ranging discussion on some formation issues that might be encountered in practice. Time is really against us now, so I will canter through myself actually one topic we did want to cover, which actually a lot of the panelists have already addressed, which is how can you preempt issues that arise in these multi-party scenarios? I think there are three key points here. The first is, if you're reviewing an arbitration agreement or considering the terms of one, look at what rules are going to be most favorable to you and what laws might say about these issues. So the law of the seat, the law of the place of enforcement, as I mentioned earlier. The applicable rules, the applicable laws are really going to be determinative of these issues. So make sure you look at all of those, and it may well be that that leads you to selecting a different set of rules than otherwise you ordinarily would. I think the second key point to preempt really is, to what extent will your client want to have control over the appointment process? Will your client be content if they are one of 10 respondents who all have to jointly nominate one arbitrator? Or will that be unsatisfactory to your client because it will want to have greater control over the appointment process? I certainly wouldn't recommend suggesting to clients that then there should be a panel of 20 arbitrators or something like that. But clients should be aware that they may lose a little bit of control over the appointment process under these multi-party rules. And that might come to a shock to them if they haven't been warned about it. And that leads me to the third key point to preempt is really, well, in the specific scenario you're looking at, so it might be the number of contracts, the number of related parties, are there any amendments that you should make to the arbitration rules per se in the arbitration agreement itself? So of course, party autonomy prevails and parties can actually agree to vary the rules. And it's much better to do so at the outset of a dispute, because obviously once a dispute has arisen, parties will always just generally, in my experience, oppose any suggestion that is being made by the other side. So those are three key points, I think, to keep in mind when you're preempting these issues. And to close in the final 5 minutes, I would be very interested to hear the views of the panelists, which I do not know myself. So I'm hoping we have some different views. But we've heard about the issues, the appointment issues that can be triggered in these multi-party scenarios. And I wonder, is the easiest way around this just to say, whilst the importance of influencing the selection of the arbitrators is obviously one of the very attractive aspects of international arbitrations, is the price to pay for the benefit of simplicity in this multi-party context, that actually we should just leave these decisions to the arbitral institutes. So in other words, that there shouldn't be any party input on the selection of the panel in multi-party scenarios. So my panelists, I will leave it to you to speak, raise your hand, or simply unmute yourself and let us know what views you have. And I do expect some sitting on the fence views as well, but over to the panel.
Well, I can start. I definitely think that the benefit of having multi-party arbitration outweighs, obviously it's a downside that they can't choose, that a party can't choose its arbitrator. But I think the benefit and the efficiency and the finality of having a multi-party arbitration outweighs that. So I would vote for the institution to appoint the arbitrator.
I shall say that I'm an appointment libertarian, so I believe in the freedom of the parties to appoint an arbitrator. So that would be my go-to initially. And of course, if the parties are unable, then, institutions are welcome to appoint. But yeah, that's the chance.
Sima, what are your thoughts?
First of all, I'm for multi-party arbitration, and I think we can avoid many challenges by a well-drafted arbitration clause and specifically about appointment of arbitrators. But at the end of the day, I think we can let arbitral institutions to appoint arbitrators.
Okay, and Cheryl, over to you. I think you might be the deciding vote, unless I give my view as well.
So I think my view lies quite strongly that we should respect party autonomy and leave it to the parties to agree and decide whether they want the arbitrators to be appointed by the institution and to give up the right to appoint their own arbitrators, or whether they want to retain that right. Because I think that's really one of the cornerstones of international arbitration. And if we take that away, I think a very large part of how we know international arbitration to be would be removed. So I vote quite strongly in favor of giving parties the right to choose.
And I mean, just on that, one point that can come up in this context, though, is when parties enter into the arbitration agreement, they may not yet know if they are going to be claimant or respondent, and if they're going to be a sole claimant, or if there's going to be 5 other claimants, or the sole claimant and 5 other respondents. And so in a sense, in agreeing to some of these multi-party appointment rules, actually, parties might think that they're retaining their autonomy and they're retaining their right to select the decision maker. But if agreement cannot be reached with other claimants or other respondents who suddenly emerge, then actually party autonomy might, to an extent, go out the window. I mean, of course, the other side to that is you could say, well, in agreeing to those applicable arbitration rules, the parties were aware that risk could eventuate. But in my experience, a lot of these issues are not really looked at in the rush to enter into arbitration agreements, which, as we all know, often are simply boilerplate. That brings us to the end of our webinar. So I'm very grateful to Ila, Ivo, Sima, and Cheryl. That's been a very, very informative discussion, a lot of thought-provoking issues, and I do feel that this is one of those areas which we are always going to see contentious points remain throughout, because as we've identified, it really, as Ivo, I think you said earlier in the webinar, on a lot of these issues, there's no right or wrong way. It really depends on your view of the world and how party autonomy, equal treatment of the parties, and consent is perceived. So with that, thank you all very much indeed for joining. Thank you to my panelists, and I wish you all, those of you participating in the Moose, the very best of luck. So take care and good evening.
Thank you, Cameron.
Thanks. Thank you, everyone.
Thanks, everyone. Bye.